Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Legal frameworks, especially in tech-heavy fields like intellectual property, are always, well, evolving, aren't they?
Constantly. It feels like the rule book gets an update every other week sometimes.
Exactly. And staying on top of it isn't just good practice, it's really essential. So today we're doing a deep dive into some potentially big proposed amendments to India's patents rules, the ones from 2003.
That's right. We're looking at an official notification from the Ministry of Commerce and Industry, specifically dated July 16th, 2025.
Okay, so our mission here is pretty clear. Pull out the crucial bits from these draft rules. We want to understand what these changes might mean for, individuals, businesses, anyone really involved with IP in India. Now, it's really important to stress, these are draft rules we're discussing. They're not set in stone yet.
Absolutely crucial point. These proposals come from the central government, using powers under the Patents Act 1970. But the draft part is key.
And why is that so significant right now?
Well, what's fascinating here is the explicit call for public input. The government isn't just dropping these rules, they're actively asking for feedback, they're published for public information, and objections or suggestions are welcomed.
Okay, so there's a window for people to react.
Yes, but it's a tight one, just 30 days from the date they appear in the official gazette. So you need to act fast if you have thoughts.
And how do people submit that feedback?
You can send comments to the Secretary, Department for Promotion of Industry and Internal Trade, that's DPIIT, at the Ministry of Commerce and Industry in New Delhi, Vanija Pawan. Or, probably easier, via email.
Got the email address?
Yep, it's errpatents@gov.in. It's a direct channel to potentially influence how these rules end up.
Right. So with that public consultation context in mind, let's dig into the substance. First up, some new definitions. Sounds a bit dry, but often important.
They really are foundational. Rule 107A introduces formal definitions that clarify who's who in patent contravention proceedings. Basically, when someone's accused of breaking patent rules.
Okay, so who are the key players defined here?
3 main roles. First, the adjudicating officer, that's the official authorized under Section 124A of the Act to make the initial decision.
Makes sense. And the others?
Then you have the appellant. Simply put, that's anyone who disagrees with the adjudicating officer's order and wants to appeal it.
Okay.
And finally, the appellate authority. This is the officer under Section 124B who hears those appeals.
So adjudicator, appellant, appellate authority, pretty clear structure.
Exactly. And if we connect this to the bigger picture, defining these roles so clearly isn't just about language. It creates a much more structured, formal system for handling disputes. You get a clearer chain of command, a defined process. It should reduce ambiguity.
Making it easier for everyone to know where they stand and what the steps are.
Precisely. It aims to build a more predictable pathway for resolving these issues.
Okay, so if you think someone has contravened a patent rule, how do you start the process under these proposals?
Rule 107B lays out the starting point. Filing a complaint. Anyone can file one.
But there are specifics, right?
Yes, 2 big ones. First, it must be done through electronic means. No paper filings for this initial step.
Fully digital.
Fully digital. And second, it has to be submitted using a specific new form, Form 32.
Form 32, got it. And what kinds of contraventions does this cover?
It's specifically for contraventions under Sections 120, 122, and 123 of the Act. Broadly speaking, those deal with things like misrepresenting patent information or unauthorized use.
This shift to purely electronic filing, that sounds like a major practical change.
It is. On the one hand, you can see the logic, efficiency, speed, less paper shuffling.
Sure.
But it also raises that accessibility question. Is everyone equally equipped to handle a purely digital process? Smaller inventors, maybe folks in areas with less reliable internet.
That's a fair point. A potential hurdle alongside the modernization.
Definitely something to watch.
Okay, so the electronic complaint is in using Form 32. What happens next? What does the adjudicating officer do?
Right. Rule 107C details their role. Once they receive a complaint under Section 124A, they first issue an electronic notice to the person accused. It's a notice to show cause.
Meaning they have to explain themselves.
Essentially, yes. They get a specific period, not less than 7 days, to explain why an inquiry shouldn't be held against them. The notice has to clearly state the alleged contravention.
And if the officer decides an inquiry is needed?
Then they issue another notice, this time setting a date for a hearing. The person can appear themselves or send a legal practitioner.
Okay, standard procedure so far.
Mostly. On that hearing date, the officer explains the accusation and the relevant laws and then gives the person a chance to present documents or evidence. Hearings can be adjourned if needed.
Now, you mentioned something about evidence rules being different.
Yes, this is quite significant. The rule states the adjudicating officer is not bound by the provisions of the Perthia Sakshi Adhinyam 2023 when taking evidence.
And that act is the main law for evidence in India, right?
Correct. So this gives the officer more flexibility in what evidence they can consider. It suggests a move towards perhaps a less formal, more administrative style of inquiry, likely focused on speed.
Interesting. Does the officer have powers to compel information?
They do. They can enforce the attendance of witnesses or compel the production of documents they deem relevant.
What if the accused person just doesn't show up?
The officer can proceed with the inquiry in their absence, but they have to record the reasons for doing so.
Okay, and then the decision.
If, after the inquiry, the officer is satisfied a contravention happened, they can impose a penalty. This must be done through a written order, clearly stating the reasons and citing the specific provisions of the act that were violated.
And the order itself.
Every order has to be dated and signed by the adjudicating officer. Crucially, a copy of the order and the proceedings record must be given free of charge to the person involved.
Right. Now, you mentioned speed. Is there a deadline for this whole inquiry process?
Yes, and it's quite aggressive. The adjudicating officer is mandated to complete the entire proceedings within 3 months from the date that first show cause notice was issued.
Wow, 3 months? That's fast for legal proceedings.
It really is. This, combined with the flexible evidence rules, strongly signals a push for much faster resolution of these patent contravention cases.
But does faster always mean better?
Well, that's the critical question, isn't it? It aims for efficiency, which is good for clearing backlogs, but does a 3-month window allow enough time for complex cases? Could it pressure parties, maybe compromising thoroughness?
It certainly puts pressure on everyone to be prepared and react quickly.
No question about it.
Okay, so the adjudicating officer makes a decision within 3 months. What if someone disagrees with that order? Is there an appeal route?
Yes, Rule 107D covers the appeal process. Any person who feels aggrieved by the adjudicating officer's order can appeal.
How do they do that?
Again, it's electronic. The appeal must be filed using another new form, Form 33, and submitted electronically to the appellate authority.
Is there a deadline for filing an appeal?
Yes, 60 days from the date of the adjudicating officer's order.
60 days. What if you miss it for a good reason?
There's a little flexibility. The rule includes a proviso stating the appellate authority may allow an appeal filed after 60 days if the appellant can show sufficient cause for the delay.
A potential safety net there. Good.
It is. Once the appeal is filed, the appellate authority issues a notice to the other party, the respondent, asking them to file a reply.
And then a hearing.
Yes. After giving both sides a reasonable opportunity to be heard, the appellate authority will issue a reasoned order. They can also grant adjournments if necessary.
And is there a target timeline for the appeals process too?
There is. The appellate authority aims to wrap up the appeal proceedings within 6 months from the date they received the appeal.
So 3 months for the initial inquiry, 6 months for the appeal. It's a clear structure with built-in timelines.
Exactly. It provides that essential second look, that review layer,
Yeah.
but still within a defined, reasonably prompt timeframe.
Beyond these specific steps for complaints and appeals, are there any other general changes that apply across the board?
Yes, there are a few important ones that tie everything together, focusing on efficiency and transparency. Rule 107E really hammers home the digital point.
How so?
It states that all communications under this entire chapter, complaints, notices, orders, everything must be transmitted electronically, and proof of transmission just needs to show it was properly addressed and sent electronically.
Fully embracing the digital age then. What else?
Rule 107F deals with time extensions. It gives both the adjudicating officer and the appellate authority the power to extend any deadline if there's a reasonable cause for delay, provided they record their reasons. They can impose costs for this or not.
So some flexibility baked in despite the tight timelines.
A necessary bit of pragmatism, yes. And finally, Rule 107G focuses on the orders themselves and the penalties.
Okay, what does that say?
Every order issued, whether by the adjudicator or the appellate authority, must be dated, digitally signed, sent to all parties, and this is key, uploaded onto the official website.
Ah, public access.
Exactly. Plus, it specifies that all penalties collected go to the Consolidated Fund of India.
That public uploading of orders seems like a significant step towards transparency.
It really is. If we connect this to the bigger picture, these general rules reinforce that modernization push. Mandatory digital communication, public orders, it all points towards greater efficiency, yes, but also significantly more transparency and accountability in the system.
And having those orders publicly available could build a kind of precedent database over time.
Potentially, yes. It could offer guidance and enhance predictability for future cases.
Let's quickly touch on the forms themselves. You mentioned new forms 32 and 33. What kind of information do they require?
They're quite detailed. The old forms 31 and 32 are being omitted, by the way. The new form 32 for the initial complaint needs all the complainant's details, name, address, contact, email.
Standard stuff.
Right, but also precise details of the alleged contravention date, time, the specific instance, a clear statement of the material facts, any supporting evidence you have, and if you're claiming damages, a tentative amount with a cost breakdown.
So quite comprehensive.
Yeah.
And Form 33 for the appeal.
Similar level of detail required from the appellant, name, address, contact info, and crucially, specific details of the order they're appealing, the case number, the date of the order, plus, again, all supporting evidence for the appeal.
It sounds like getting these forms right with all the required information is going to be critical, especially with the electronic system and tight deadlines.
Absolutely critical. Missing information or errors could easily lead to delays or even rejection. The onus is really on the filer to be thorough and accurate right from the start.
Okay, so let's try to synthesize this. We've talked about clearer roles being defined, a major shift to a fully electronic system for complaints and appeals.
Right, significantly faster timelines, especially for that initial inquiry phase, just 3 months.
Plus, increased transparency through things like digitally signed orders being uploaded publicly.
And specific detailed forms, Forms 32 and 33, that need careful completion.
So what does this all mean, really? What's the big takeaway?
Well, it's a clear attempt to streamline and modernize patent contravention proceedings in India, making them faster, more digital, more transparent.
But it does raise that important question, doesn't it?
It certainly does. With this heavy emphasis on digital communication and these very accelerated timelines, how will these new rules practically impact accessibility and the quality of dispute resolution for everyone involved?
Will the digital-first approach level the playing field? Or will it create new barriers for some, needing significant adaptation?
That's exactly it. It's a major evolution in how patent rights could be enforced in India, and watching how it plays out in practice, assuming these draft rules become final, will be really telling.
It's definitely a lot to absorb, but understanding these proposed changes now is vital for anyone navigating India's IP landscape.
Couldn't agree more. Being prepared is key.
Well, thank you for helping us unpack all of that today. And thank you for joining us on this deep dive. Keep exploring, keep asking questions about these regulatory shifts. We'll catch you on the next one.